Welcome to Gracefully Graying. I'm your host, Attorney Henry Gornbein. Please watch this video as well as our other videos on our YouTube channel, and please go to and like Gracefully Graying, our website. Today on Gracefully Graying, I'm pleased to welcome as my guest Steve Malach, who is a partner with a law firm of Lipson, Neilson, which I have recently joined as of counsel. We will be discussing some key issues in estate planning aimed at really a broad audience. Steve, welcome to Gracefully Graying.
Thanks for having me, Henry. My pleasure.
Pleasure having you. First of all, why don't you tell our viewers a little bit about who you are and your background?
I've been practicing for 40-some years, initially in a general practice, a lot of litigation, a lot of trial work, commercial stuff, real estate, and then focused the second half of my career basically on probate, estate planning, and probate litigation. I have handled thousands and thousands and thousands of probate matters. I have prepared through the Center for Estate Planning thousands and thousands and thousands of estate plans. Some people believe, because there's no survey, that we have done more estate plans in our office than any other law firm in the state. And all that experience has been brought to bear now at the Center for Estate Planning and Neilson, where I've been for the last dozen or so years, in which we've now welcomed you to our family.
Steve, people don't like to talk about estate plans, death, taxes. These are kind of taboo. Elvis didn't have an estate plan. Aretha Franklin more recently has been in the middle of litigation for failure to properly plan. Prince did not have an estate plan. Larry King apparently has had problems with an estate plan. Why should someone have an estate plan, Steve?
Well, first of all, let me answer your question by backtracking a moment. The reason people don't do estate plans, in my experience, is there's nothing instantly in it for them. People sign documents, and as you know, more often than not, the documents come in a binder, and you just put them away. It's the end of that. Those that have foresight, or those that have had a family member die, come to realize having a plan in place before you get sick, before you pass away, makes it easier for those around you to help you while you're sick and deal with your affairs after you passed away. It's one of the more unselfish acts you can do, because you're making a plan, spending time and some money to make sure that family knows what to do for you, rather than guess, or even worse, run to probate court to have a judge tell you what you're going to do.
Steve, tell our viewers what a basic estate plan consists of.
Well, you find that there's a typical so-called package of documents because they all interact with one another. Everyone knows what a will is. What folks don't oftentimes realize is a will only operates and is only functioning and is only effective in a courthouse, in probate court. And of course, whenever I mention the word probate, people cringe. Yeah, rightfully so. It's slow, it's cumbersome, it makes all your affairs public so anyone could look up what's going on. And there's a better way to do it. Among the documents is a living trust, in which you are the head of the trust, and it directs essentially yourself to take care of yourself or your spouse during a lifetime, and then indicates, similar to a will, what happens after you pass away. The difference is these trusts are designed to operate outside of the court system. Your family member can effectively use that trust at their kitchen table after you passed away. That's not to say they can't use a lawyer if they want to or need to, but it certainly is designed to avoid the court system. In conjunction with the will and the trust, you have medical powers of attorney, you have financial powers of attorney, and 3 or 4 other related documents that all integrate from one to the other.
Steve, we're going to be discussing all of these as we go along, but first of all, what happens if you don't have an estate plan, if you don't even have a simple will?
Well, then there's a third person that would need to join our conversation today, Henry, and that would be a person wearing robes called a judge. and a judge who, of course, is not family, a judge who's a civil servant, and a judge who you got to schedule to see gets court papers, looks at the array, along with about 50 or 60 other cases that are all scheduled for hearing same day and time. And the judge decides what medical care you receive. A judge decides who's in charge. A judge decides where you're going to live. And that's during your lifetime. If you don't have a plan in place and you pass away, well, now a judge is going to decide who's in charge of your affairs and who gets what. And I don't think there's too many people that would want to do that. You know judges as I do. I have, and I imagine you have interviewed judges in the past, and oftentimes they promote estate plans. They don't need extra work in their courtroom, trust me.
Let's start with a will. What are the key provisions of a will that our viewers should be aware of?
A will appoints someone to be the head of the estate. Used to use the words executor and executrix. That was changed in 1979 to the generic non sequitur term of personal representative. And you can have an original person. If you're married, it's typically your spouse. And then you name an alternate, typically one or more of your children. You can have co-personal representatives if your family dynamic indicates and suggests that's the right thing to do to get the job done. The will also creates, appoints, and designates devisees. Devisees are people that you want to receive what largesse you have. Maybe it's equal split between your children. Maybe you're providing for charity. Maybe you're providing for other individuals in your will. And that will, once the judge says it's okay, would direct whatever your devise is to those individuals. The will also provides for payment of your funeral bill and last taxes. Remember, Henry, there's a saying, there's death and there's taxes. The saying is not there's taxes and then death. Even after you die, you still got to deal with Uncle Sam and your taxes. There's no way of getting around it. Will, trust, wouldn't matter. But that's the basics of a will that a judge oversees all of.
What are specific bequests that people can designate in a will? Tell us a little bit about that from your experience.
I've had many clients devise in a will or trust, as far as that goes, to charities, to universities. I had one client who had no children and had several $1 million sprinkled, so to speak, their money around the Carmanos Cancer Center, which is local here in Detroit, Michigan, the food bank, St. Jude's Hospital. And I visited these places on behalf of these clients because the bequests were sizable and we wanted to make sure. And the bequests can also be very specific for St. Jude's or Carmanos or the University of Michigan, specifically what the funds are to be earmarked for, as opposed to just put into a general fund. Many clients don't care. They just want the money to go to the organization, and the organization can figure it out. But in many clients, because of a life experience that they may have had, or a interest close to their heart, want it devoted, for example, for cancer research in pediatrics, one example, or heart research for pediatrics, or Alzheimer's, or palliative care, specifically for older people. And I'm seeing those more and more of those kind of bequests all the time.
Now, also family bequests. I mean, someone can say, I'm giving certain pieces of jewelry or certain heirlooms to different children or other relatives, or there can be a pet that can be left to someone. So these are also handled by specific bequests, correct, Steve? They
are. In a will, it's a little messier than if you do it outside the court system in a trust. Yes, and the reason I say that is if you bequest a certain item, then the court, remember what I said about death and taxes, Henry, right. They get their inventory fee, which is in Michigan 0.5% of the gross value of a probate estate. So if you want to give a certain ring, for example, and it's mentioned in the will, then the court's going to be looking for an appraisal so they can attach a value to it, so they can attach a tax to it. But you can do that. When you have it in a trust, by the way, you don't have to go through that rigmarole. And the other thing our office does, to eliminate any of these issues is we provide a separate document that our clients can sign long after they've signed their trust and will and powers of attorney. They can fill it out at home at their leisure, indicating the item that they're talking about and who they want to receive it. And while many law firms don't provide this particular document, I have found it to be useful. And years ago, I created this document because, believe it or not, if the number one issue that comes up when people pass away is people's personal effects. It is what it is. One way to eliminate that, if not to give it away before you die, which is easy to do, is to indicate in writing who you want to receive it, whether it's in a trust or a will, or as I suggest, a separate document.
Steve, tell us about a trust.
A trust is a contract, Henry. It's an agreement with yourself. No one else signs it initially. You appoint yourself as the original trustee. You are called, not the creator, it's called a grantor, but that's essentially a legal term meaning creator of this contract. And the contract says, I'm making a trust for myself. I'm in charge of this trust while I'm alive. I'm the sole beneficiary of this trust while I'm alive, and I'm in charge of it while I'm alive. And that gives you full control during your lifetime. That's without court involvement. The document also says, if I become sick, or when I pass away, here's who I want to be in charge of my affairs. If I'm still alive, then you're still the primary beneficiary. That would never change during your lifetime. And the document, and it can be 30, 50 pages long to say all it needs to say and meet all the compliance requirements of our society these days, says, when I pass away, pay all my bills, pay Uncle Sam. Here's some specific bequests, if there are any, whether it's personal effects or charities. And then the residue, what's left over, I want assigned and given out to, could be minor grandchildren or minor children in trust for a period of time, or it may be an outright distribution. I find most estate plans, trust wills, take somewhere from 9 months to a year from start to finish up. Typically, unless you're holding funds back in a trust for a good reason, or, for example, family businesses or real estate that is not instantly liquidated, in which case sometimes these things can go on more than a year.
Can a trust be used to avoid probate?
That is their primary objective, but I have to have a caveat. As you know, Henry, I am involved in some family fights. And while trusts specifically say, every single one of them, this is not to be registered with a court, I want to keep it private. If the family fight can't be resolved, and sometimes they can, if they can't, well, then that trust that's not supposed to be registered with a court, guess what? It gets registered with a court. And now everyone's lawyered up, and you're into a court fight, typically involving one of two issues: undue influence in the creation of the document, or a claim of lack of mental capacity in the creation of the document, one or the other.
I have a question for you, and that is, often you have in a trust or a fairly complicated estate plan a clause that says if anyone contests this, he or she will be subject to sanctions, attorney fees, or paying the winning side's attorney fees. Are those enforceable?
Well, what you're talking about is in Latin called an interim clause, which, as the word suggests, is terror, fear. And what they typically say, not only is it fees and costs, it says you lose your interest. You get zero. So let's say there's 4 children, and this one child, for whatever reasons, is designated to receive less than the other 3. And they don't like that. Well, they don't like it isn't a good reason to contest this. If they want to go to court for that reason, and they bring that challenge, and there's not probable cause to bring the challenge, well, then they lose their interest entirely. It's a heavy-handed paragraph. It's enforceable in the state of Michigan. In fact, it's enforceable throughout the country. As you know, I also practice in the state of Arizona, and I've had those same issues come up in litigation in the Phoenix area, which is where one of our offices is located. Seen it before, we'll see it again.
Steve, what is a power of attorney?
A power of attorney is a document you sign during lifetime to take care of yourself during lifetime. Now, truth is there are thousands and thousands of versions of powers of attorney. The two kinds typically done in the estate planning world is one for medical, artificial life support, my care, organ donation, things like that, HIPAA, things like that during lifetime. And the other kind of power of attorney is financial, dealing with lawyers, Social Security, Medicare, a nursing home, accountants, taxes, IRS, etc. And these documents are designed either to be used instantly the day they're signed, if that's what the client wants, or some clients insist that those documents are effective when a doctor indicates in writing that the client themselves can't handle their affairs. And these powers of attorney are very important because usually, Henry, you get sick before you die, usually. So these documents come into play, and clients have this notion that their estate plan is all about after they die, and I spend an equal amount of time going through the powers of attorney, explaining the importance to them of clients, and if they don't do powers of attorney, well, now we're back in the probate world with what's called a guardianship or a conservatorship to that same judge making all the decisions that really should be kept in the family.
Tell us about medical designations.
A medical power of attorney has gotten a little more interesting and complicated, particularly since Jack Kevorkian, I'm sure we all remember that name here in Michigan, made quite a brouhaha about artificial life support and the decisions made in that regard. First of all, it does indicate our documents, and most law firms have a specific definition of when artificial life support should be deployed or not. And clients have very personal feelings about that, and we'll tailor the document to meet their feelings. It also provides with HIPAA and all the other compliance that exists in our world that are here to stay, to make sure as you hand it to Medicare, as you hand it to a doctor's office, as you give it to the hospital, it covers all the bases that that institution would require in order for that person to make a decision. You have to remember, when someone's in the hospital in critical condition, auto accident, they're in a coma, they have dementia, and they can't make the decision, somebody has to make the decision for them. It's either going to be a judge in a courtroom who doesn't know anything about your whole family, or it's going to be within the family, the person or persons you've designated to make that decision, and that's who the hospital and the doctors will listen to.
Steve, what is it important to have a guardian? And tell us a little bit about guardianships and conservatorships.
Well, lacking a power of attorney for medical or lacking a power of attorney for financial, if you become sick, who's going to handle your affairs? Who's going to make your medical decisions? The answer is a judge. A petition for guardianship or petition for conservatorship is filed. A guardian handles living arrangements and makes medical decisions. A conservator, usually, but not always the same person, handles your financial affairs while you're alive. Make sure your bills are paid, make sure your taxes are complied with, and deals with any contractual obligations. I like to tell clients that power of attorney is very powerful. It only, the financial power of attorney only is missing one thing. That is the right to vote, because our government won't give you that right in a voting booth. Everything else is in there, and separate from that is the medical power of attorney. Again, oftentimes it's the same people, but I've had clients say, you know what, my son has an MBA, I want him to be on my financial power of attorney, but my daughter's a nurse. I think she should be in charge of my medical affairs. So sometimes there's a difference between one and the other. And again, the beauty of powers of attorney is they avoid guardianship and conservatorship. If you don't have the powers of attorney, the judge will appoint a guardian, the judge will appoint a conservator, and the judge will supervise their decision-making.
What about funeral designations? I mean, the problem with an estate plan is it takes effect normally upon death, but if you want a certain type of funeral, if you want certain arrangements, how do you make sure that that is taken care of?
Well, there's two ways to do it, Henry. One, you put it in the documents. It doesn't hurt while we're doing the estate plan to put it in there, but you're right. People don't rifle through or locate these documents the day someone passes away, and what do? What I tell those clients, and there are those that are keenly interested in this, is make arrangements directly with the funeral home or your church or your synagogue, as the case may be. You can pick the outfit you want to wear. You can pick the music. You can select the clergy that you wish to engage for your funeral, etc. Pay for your funeral plot ahead of your cemetery plot ahead of time. So the clients that are keenly interested in that, I tell them, don't leave it up to your family and children. Make the arrangements now. Pay for the arrangements now. Make it known in the family, this is what I've already arranged for, and then it's a fait accompli. It's done.
You mentioned that certain things are inevitable, including death and taxes. Let's talk about taxes. How important is tax planning, and what are some key issues that our viewers should be cognizant of with regard to tax planning?
Well, that has, during my 40 plus years of practice, been, in terms of death taxes, also known as estate taxes, is a political football. The folks in Washington love to monkey with this. The fact is, in years past, it represented about 3% of the gross revenue that the government received. That number's gone down as a sliding scale when the exemptions increased. When you and I were practicing law back in the day, that number was 600,000. And anyone who passed away with more than that, well, there was a death tax, an estate tax to pay, which is pretty onerous, by the way. It starts at 38% of the value and it goes up to 55%. So it's a pretty heavy tax. And you got to remember, this is a tax on dollars you've accumulated that already have been taxed. So there's some resentment in this regard. Now, when Obama came into office, the elder Bush changed it in 2001 from 600,000 up to 3 million. Obama came into office and it gradually moved through the years. He took it up to 5.5 million. President Trump, he doubled that while he was in office. So it's now over 11 million a person. And if you're a married couple, times 2 is 22 million. So the amount of people that would be subject to the tax is negligible at this point. It's big money, but for a very, very small amount of the population. And nowadays, I'm just finishing writing an article, the Biden administration is considering rolling all of that way, way back. There's capital gain tax issues that also are subject to these politicians looking at ways of increasing revenue. Right now, if you pass away, your children, your family enjoys what's called a step up in basis. So if you bought Apple stock at $8 and the day you died, it's $200. Your family inherits it at $200, and all that increase during your whole lifetime is stepped up. So there's no tax to ever pay on that initial gain during lifetime. There's also talk about changing that or rolling that back. Every time we change presidents, I'm writing an article and watching keenly because there are changes that are made every time.
Everyone's looking for revenues, and so it's a political football. Steve, are there any other documents that are important as part of an estate plan that we haven't covered that should be mentioned?
The two things one thing I like to say to clients is a trust, when we create it, I get it, it's a contract, it's an agreement, but the way I like to conceptualize it with the public and clients is a trust is a box, it's a container that the lawyers make, and it's empty the day we make it. There's nothing in it. The funding of it, the transferring of assets into that is key. If you do a trust and don't put your assets in the name of your trust and then you pass away, well, then the trust is empty. Now we're going to probate court to have a judge fill the trust for you. So what the documents we prepare, along with all the documents we've just mentioned, are assignments of business interests, are deeds of real estate into the name of the trust. So we help the clients kickstart, so to speak, the labeling, the renaming, the retitling of assets, putting them into that container, putting them into that trust. That's key. I won't follow a client, no lawyer will, into the bank or the credit union or contact their financial broker. They will do that. And I just spend a lot of time during our meetings harping on the importance of making sure your designations and your accounts are properly labeled and the beneficiaries are properly listed, So again, nothing slips through into probate. And again, things end up the way you want them to end up. So those are some additional documents we'll help the client start with, including the personal property list I mentioned before, which also is included in your trust.
Isn't it also important to make sure that your heirs know where, first of all your documents are, second of all, where all your financial records are, and otherwise, you're creating a treasure hunt upon death?
You're asking, well, all your questions have been great. Obviously, you've done some research in the area or have had the experience yourself. And the answer is that's changed through the years. I still occasionally, and certainly in the past, have made an extra photocopy of records. Clients are given a binder typically that has tabs, that has pockets in it, so they can keep everything together in one spot. And yeah, it's important for someone to know besides you where that binder is. I also have clients say, Steve, can we get an extra photocopy? I want to leave it to my children. They're coming in for the holidays. Why, sure. Now, in the last 5-10 years, the copying has changed. We're in a new world, Henry. Now they want discs. Now they want flash drives, or they want a PDF emailed to them of the documents they just signed, which, by the way, we do at the same time they come in to sign their documents. Whatever copies they want then or later on, we can replicate for them in whatever manner they want, because oftentimes children are out of state or they're so digitally savvy. There's no need they don't want to see paper anyway. They want to see everything on their phone. So we provide them that technology by way of a flash drive or a disk or a PDF so they can see it on their phone if they want to.
We're in a whole new world. What can you say? Tell us about typical costs.
Well, it'll range from metropolitan city to metropolitan city. It'll vary from law firm to law firm. You can spend $5,000, $10,000. You can spend $1,000 to $3,000. I think the sweet spot for estate planning in the Detroit metropolitan area is around $2,500, give or take, for that so-called standard package. Phoenix area, for example, where I also practice, it's about 30% more. Why? Cost of living there is higher. Wages are higher. Real estate costs more. New York, going to be double or triple what I just said. But here in the Midwest, that's the sweet spot cost-wise. There are few firms, very few, that charge by the hour. Some do. Most of them have a flat rate in the ranges I just mentioned.
Steve, we're almost out of time. Would you provide us with 5 takeaways for our viewers before we sign off?
Yeah, I don't know if it'll be more or less than 5, but I'll give it a shot. Procrastination is the enemy for the clients and family. Don't do nothing. That's the worst. Do your research. Go with a law firm that you are comfortable with. Make your estate plan. And they're called living trusts because they live, they breathe. And as time goes on, a young married couple, for example, that has young kids, they're focused on guardians in case, God forbid, they pass away, who's going to raise the children. Fast forward, when those same clients are 40s or 50s, now their children are in their 30s or 40s. Maybe they're ready to assume the throne. Certainly don't need guardians anymore. And then you have the third stage. As you get older in life, now you want to talk about charities. Now you want to talk about grandchildren. Now maybe your daughter married a no good son-in-law that you want to eliminate from the process. So make a plan. Be mindful that it will change as your life changes. That's certainly the biggest, most important thing I can tell your viewers. Don't do nothing. Do something and recognize it can change over time. Other than that, go with a lawyer or a law firm you know, that you trust, that is experienced in the area, that's reasonably priced, and are straight shooters. That's how we practice at Lipson, Neilson and the Center for Estate Planning.
Steve, I want to thank you for being our guest on Gracefully Graying. We're out of time. I want to thank our viewers for watching Gracefully Graying. And again, please watch this video on our YouTube channel and go to Gracefully Graying to see all of our videos, as well as all the information that we provide for everyone at gracefullygraying.com. Again, thank you for watching.